The record of Africa for combating impunity for serious crimes underscores the importance of the membership in the ICC of African countries, including South Africa. So what is this record? Well, the successful trial of the former dictator of Chad, Hissan Hibre, for war crimes sets a new benchmark to end impunity in Africa, and that was set up by the AU. It marks a significant step forward in holding high-profile perpetrators of crimes to account in Africa, and could be an important model of new hybrid courts that can reconcile the often conflicting demands of international law and national sovereignty. The case is the first exercise of universal jurisdiction on the continent, and the first time a former African head of state has been prosecuted and punished for crimes under international law before a national court, and that is Senegal. And I myself, while serving as judge and president of the Rwanda Tribunal, appreciated that the success of that tribunal was largely due to the cooperation from African countries in terms of arrests, transfer, and protection of witnesses. The Special Court for Sierra Leone convicted and sentenced to 50 years imprisonment head of state Charles Taylor of Liberia for war crimes committed in a neighboring state. And of course, more recently, Sudan tried and convicted the former president, Omar al-Bashir, for corruption. And it's hoped that he would be transferred to the ICC to face more serious charges. Africa's support for the rule of law, justice, and human rights is also very steadfast. African states have been in the forefront of important international and regional endeavors to ensure respect for human rights. The African Charter on Human and People's Rights, in its preamble, stresses that freedom, equality, justice, and dignity are essential objectives for the achievement of the legitimate aspirations of the African peoples. And Article 4 of the AU's Constitutive Act firmly states that impunity should not be tolerated across the continent and that victims must have access to justice. Under the auspices of the AU, African countries have also demonstrated their commitment to ensure accountability by establishing the African Human Rights and People's Rights Commission and the African Court of Justice and Human Rights. Let us also not forget that African countries were leaders in establishing the ICC. They played a key role in negotiating and adopting the Rome Statute in 1998. They were also actively involved in transforming the idea of a court to reality. Senegal was the first state to ratify the Rome Statute. When the court was finally established in 2002, 17 of its initial states parties were African, and 5 of the first 18 judges were from Africa, including me. The continent of Africa boasted the largest number of ratifications to the Rome Statute, thereby throwing their collective weight behind ending impunity for serious crimes. However, Africa has concerns that are shared in common with many other states that have withheld ratification of the Rome Statute. The African Union complained of politicization and misuse of indictments against African leaders by the ICC, and that prosecutions could undermine sovereignty, stability, and peace. The focus for some time, as we know, by the ICC prosecutor was on African countries alone, and that gave rise to many concerns and criticisms of selective justice, particularly in the light of the failure to pursue accountability for serious crimes committed by actors in Western states, in Iraq, and in Libya. Criticism is also raised over the participation in referrals and deferrals to the ICC by 3 veto-holding members of the UN Security Council who are not members of the ICC. So the perception of politicization, injustice, and illegitimacy is inherent when three major countries can escape scrutiny by the ICC of alleged violations within their own countries and that of their allies. We should recall that 5 of the 8 countries where the ICC is investigating have themselves referred the relevant allegations to the ICC. These self-referrals show that states that were unable or unwilling to prosecute the serious crimes in their countries sought the benefit of accessing justice through the system of international criminal justice. They also show that the ICC, far from undermining national sovereignty, works with its state parties to assist them in their efforts to render justice to victims and to comply with their international legal obligations. In this way, they reflect a welcome development in international law and relations, namely a conception of sovereignty that embraces the protection and promotion of people's fundamental human rights. So it is evident that the resolution on immunity and threats of withdrawal from the ICC arose because of the profile of the individuals indicted and not because of the seriousness of the alleged crimes or the number of victims, nor was it an abandonment of the principle of no impunity. The notion, however, that political power can be a safe haven for impunity would create a dangerous double standard for accountability. It is also incompatible with international law. However, significantly, no African country heeded the AU call for resignation from the ICC. African countries have been steadfast in their support for the ICC, and if there are any concerns of precarity or threats to international justice, then in my view, one should not look at Africa, but to the north, from where these threats against the ICC prosecutor emanate. So, to answer the key question, precarity or prosperity, I would say African countries are well on the way towards prosperity in the future. Thank you.